I am back, YouTube, and this time the last video I did was my second semester overview, and I talked about LRW, but I realized that it went kind of long, so I realized that I needed to elaborate on something. Okay, so I talked about contracts, which was the same. I talked about criminal law, but LRW, I forgot. I don't know how, but I forgot. It was a little different the second semester because you did do 2 papers. You didn't do 3. So the first semester you did 1 paper where you pretty much kind of did it together. It wasn't that bad. And then you did 2 papers on your own. The first one wasn't graded is basically what it was. Second semester you did 2 papers, but what I didn't mention is that you also did an oral arguments. For those of you who do not like public speaking, this can be very stressful to you. For me, it was a piece of cake because I talk a lot anyway, if you haven't figured that out by now. I've had to give previous presentations and stuff like that in front of students and exams and different things like that. So I don't have a problem with public speaking, so it wasn't that bad. But what I really want to kind of elaborate on is there was also an LRW exam. So first let me walk you through what I feel was beneficial about the LRW exam. It was typically, you have your 2 classes and then you turn in an LRW paper way before you take the exam. So then you only have to worry about 2 classes. And again, for you guys watching that are just starting to watch, this is a part-time experience. I am a full-time employee, so I only have 3 classes during the semester. So in the second semester, you think that you're going to have your 2 exams and then your 1 LRW paper due at the end. But you actually have an LRW exam, and depending on how good your LRW director is, it could be a piece of cake. Our LRW director gave us a study guide that was basically the test. It wasn't the test, but it was if you studied the study guide, you knew what was going to be on the test and you can answer it. Just a little tidbit about that. I wouldn't have needed to study the study guide so rigorously if I had took better notes about the research engines and different things that we talked about in LRW. So I would say don't lean on having a great director that does a study guide, because they may not. They may treat it like a regular exam at your school. So pay more attention. What happened to me is I listened and my professor had PowerPoints, but I was really more worried about conducting this paper, getting this paper done. So knowing exactly what search engines were and what they do and certain definitions and things like that was not a big deal to me, because I just focused on my paper. I'm like, when can I start working on this paper? Because it sounds like it's going to be a nightmare. So I would say take better notes than I did about what when they talk about Amger and the different books and what they're used for and the definitions for those. And here's the bad thing about the LRW exam. It had stuff from the first semester because you learned about research the first semester. So the second semester was just a review of what you learned the first semester, and then you kept going and added a little bit to that. So just make sure you take good notes in LRW and treat it like a regular class, because there is an LRW exam at the end, and it's for me, for the part-time students. For the full-time students, I did hear that they were on Friday. For the part-time students, they were on Saturday from 8 a.m. to noon. Okay, so the last thing that I didn't tell you about is the oral argument, which is what I mentioned earlier. So the oral argument, you write your 3rd paper, you turn it in, and your oral argument is basically your verbal. It's what you think you see on TV, where they just stand up and argue their point. But it's not exactly like that. It's what they do when you listen to the Supreme Court and they ask them, they argue their different sides, and then the Supreme Court justices will interrupt them with questions or, well, how can that be true if, different things like that. The oral argument, I felt like it was going to be okay because I'm good at public speaking. Other people weren't. But I also felt like, I don't really know, like I didn't prepare for it as much because I felt like I've already written a paper on this, so I should pretty much know what I'm talking about. Here's why I'm taking this a step further to discuss this. I literally talked about things in my oral argument so simple, and I broke it down, and just using the oral argument to talk about my case and say what I wanted to say actually helped me understand what my paper should have said. So in the paper, you have the issue, you have the facts you have to list, you have the rule, you have the application, the explanation paragraph where you're going to explain the cases that you're using and how they connect to your case. And then the application is where you're going to apply your case to the situation. So apply your facts to it. So I feel like the explanation paragraph is you just, going over what happened in the other cases. But the application paragraph, it's you using your creative ability to persuade and to find a persuading way to say and get to the reader to understand why the court should rule in your favor, why the judge should rule in your favor, why this case that you researched is the same thing and should have the same outcome, meaning guilty, not guilty, whatever the outcome is, as what you wanted to have. And in using my words to explain that, I did way better because I was trying to be legal about it. But it's really, really simple when you think about it, and you have to try to make it as simple as possible. You want the reader to completely be able to follow along. This happened in the other case. This happened in my case. Here's how those two tie together. And you literally go sentence by sentence using the facts, and you take, okay, A fact, this happened, here's how those two tie. B fact, this happened, here's how those two tie. That's literally how you're doing the application paragraph. All the meanwhile, you are being very persuasive in describing why this applies to your case. So personally, I felt like the prep that I did for the oral argument, the way that I thought about arguing orally was completely different than the way that I thought about writing. And you'd think they'd be the same, but they weren't. And after I did my oral argument, I was like, this helps me understand this case way better. I should have done this before. Why didn't we have this assignment before? So it may not be the same for you, but I'm just, again, these are my experiences. So that's kind of what I thought. So your professor may be like, that's next semester, or that's second semester, or that's the end of the semester. Don't worry about that now. But go to another professor. Go to your LRW director. Or explain to your professor that you just want to know the procedure and how to orally argue it in order to be able to better write your current paper, even though oral argument isn't until second semester or later in the semester. So they're very willing to help you understand how to explain it and how to apply it so that the reader can understand. But I do know that it just helped me be able to simplify it better. And I know that I can say that I got one of the highest grades in my class on that. I think it was out of like 50 points, and I may have gotten a 49 or something like that. So that was the only thing I probably got an A in, and it was only like 10% of the grade. Nevertheless, I think that the opportunity was a really good opportunity. It was great practice, And if any of you are thinking about doing moot court, it's kind of good practice for that, to decide if you want to do that or not. Because if you can do that, then you might want to apply for moot court too. Anyway, I got really high marks. Of course, you just heard my grade. My professor had nothing but good things to say, and she actually she is over the moot court, and she actually wrote in my comments that she hopes that I apply for the moot court. So if your school is the same as mine, you will have real, like other 3L lawyers, or a real judge, or a real lawyer, or three different people that are going to act as the Supreme Court justices to answer questions. And what they're going to do is, you're going to be explaining just like I'm talking now, and you're going to try to finish every sentence, and they're going to interrupt you with questions and say, well, how does that make sense if blah, 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 blah. What you have to do to prepare for that is write down, what kind of questions would I ask me? What kind of questions would I ask my opponent? What kind of questions do you think they're going to ask based on what I say? You just really, basically, you need to be prepared for the questions, because that's a big part of it. If you can stop what you're saying when they start talking, because they are, the judges, you stop talking when they stop talking, and you say, like, yes, Your Honor, and you answer the question, and you try to answer it as detailed as possible, but quickly, so you can get back to what you were saying. If you try to memorize it, what's going to happen is you're going to get interrupted, and then you're going to completely lose your mind, because when they ask you questions, you're not going to remember exactly what you wanted to say next, and it's just going to drive you crazy. So just try to be a little calm about it, and understand that hopefully for you it's about 5 to 10% of your grade. It's just for practice, and it's designed to help you, especially if you're going to be a litigator. So I think that it really helped me. I really think I want to do moot court if I have the time, because I am part-time. But I wanted to explain that, because that was a big part of my second semester, and I really enjoyed it. But a lot of people did not enjoy it. Some people didn't do as well as they wanted to. And I just thought it was a great experience. So I will tell you that the first thing that you'll say, if I can remember, is, hello, my name is blah, blah, blah. You're going to say, may it please the court, and you wait for the judge. They're not going to say, yes, it pleases the court. They may just kind of nod, or they may just sit there and look at you, but you're going to say, may it please the court. My name is blah, blah, blah. My client, blah, 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 did not commit murder because blah, blah, blah. You're going to give a little snapshot into what you're going to be talking about. But the first thing, the basic introduction is, may it please the court, your name, your client's name, and then a little snapshot of what you're going to be talking about. So good luck on the oral arguments. Good luck on LRW, and if you have any questions, please let me know. I think I might have a clip on my phone or something from practicing my oral arguments, or I might have an old file or something that I may be able to drag up if you have any questions or anything about that. So let me know, and I'll try to help you out. That's it for now. Bye.